All right, we're continuing with the judicial branch, slide number 43 and 44. Like the executive branch and the legislative branch, the judicial branch is an independent branch. All right. Again, remember, they are co-equal branches: the legislative, executive, and judicial. They're all at the same level in our Constitution. The difference is they are appointed by the president, and they're not elected by the people. Okay, so the judiciary is not a democratic institution. And its role is different in some ways from the other branches, and it's a little more controversial. And when I say it's not political, is the way the founders set up our system is you don't want judges to be beholden to the people, to the whims and the changing desires of the people. You want them to basically decide legal cases and deal with, again, specific legal principles in deciding law. You don't want them to be swayed back and forth by the changing winds of opinion by the American people, okay? If you move on to slide number 45, within the federal judicial system, the Constitution provides for the Supreme Court only, and then it gives Congress the power to create all lesser branches within the national judiciary. Okay, so in other words, Congress, if it really wanted to, all of the district courts we have, the federal district courts, Congress could literally eliminate them within a day or less, as long as it takes for them to pass that type of legislation. They can do that. All federal judges are nominated and appointed to office by the president, but they're subject to confirmation by a majority within the Senate. Unlike the president, senators, or congressmen, there is no age, residency, or citizenship requirements for the judiciary. In fact, there is not even requirement for legal training, although implicit in that is they're going to get some legal training, obviously. If you look at slide number 46, they hold their offices during good behavior. What does good behavior mean? What is the absence of good behavior? The founders never specifically said. So generally speaking, once judges are nominated, they basically serve terms for life, and they're rarely, if ever, removed. Alexander Hamilton in Federalist 78 said that the judicial branch would be the weakest branch because they have neither force nor judgment. Okay, in other words, Congress can basically execute authority through its spending authority. They can withhold funds or give funds to make things happen. A president, the executive branch, obviously can execute laws. It's very active. Whereas the judicial branch has neither force nor judgment, okay, only will. And so that's where Hamilton felt that it would be the least powerful branch. Is that true today? No. Basically, the courts tend to write their own laws and have a lot of power and force. Again, we'll talk about that a little bit further on in this discussion. But if you look at slide number 47, that is probably the clearest way to describe the three different levels of the federal judiciary. Okay, at the lowest level, you've got district courts. Okay, there's 94 districts in all the 50 states. There is no appellate jurisdiction. They just have original jurisdiction. In other words, if there's a federal case and it's the first time that case is presented, you're going to appear before a district court. Appellate jurisdiction simply means that you can appeal to a higher court. Okay, so in other words, within the district courts, they're not hearing appeals from lower courts. They are the lower court. They originally hear the case. And then you've got the mid-level. It's called courts of appeal. It's the intermediate level. There's 12 regional circuit courts, including the DC circuit. There is no original jurisdiction there. All they hear are appeals. Okay, and then the Supreme Court is obviously the highest court in the land in our federal system. There's 9 justices that meet in Washington, D.C. They primarily hear appeals. They have what's called primarily appellate jurisdiction. There is a limited original jurisdiction in cases involving states against states or involving something involved with a foreign dignitary. Other than that, basically all of the cases they're appealing or hearing are appeals. Thousands of cases get thrown to the Supreme Court every year. They take between 70 and 100. Usually it's about 70. Okay, so in other words, very, very selective. It's got to be a case or a controversy that has high national interest, high national import, something that has to get addressed. If you look at slide number 48, you can see all of the different federal district courts, okay, and the courts of appeals throughout the country. What's interesting, if you look at the West Coast, that is the 9th Circuit. There have been talks of reform within that circuit, of breaking it into perhaps 3 or 4 different districts because of its size. It was originally decided at that size, again, 100 years ago or so, when there was a lot less people there living there. But obviously now there's a lot more people living there in that area, and so it could be broken up into different districts. Again, Congress can do that. This entire map and how the districts are set up could be changed by congressional whim at any given time. If you go to slide number 49, you can see the current Supreme Court of the United States, and you can kind of just take a look at that there. If you go on to slide number 50, it talks about just, again, the Article 3 power. It's a constitutional grant that the Supreme Court hears both original and appellate jurisdiction. Again, a jurisdiction is the authority that court has to hear a particular case. Again, original jurisdiction is the authority to be the first to hear that particular case. Move on here, slide number 51. Again, I kind of already talked about that. Appellate jurisdiction is jurisdiction where the court hears appeals, again, a particular individual or a company or some organization did not like a lower court ruling, so they appeal to a higher court. Again, they're called appeals courts or appellate courts. Article 3 of the Constitution gives Congress the power to create exceptions to the Supreme Court appellate jurisdiction, whereas its original jurisdiction is unalterable by Congress. In other words, the Congress can't change the district courts and their ability to hear original cases, but appeals can be modified by the court. This is something that I addressed in the 9th chapter of the book that I wrote with my fellow co-authors. Is one of the ways that perhaps the culture wars in our country can be calmed down or perhaps dealt with at a more effective level is Congress can decide, like in like major issue cases. Pick abortion, okay, is just a great example. The Congress can basically say, listen, in all cases dealing with abortion, appeals cannot go to the Supreme Court, but must be decided on a lower level or must be decided within Congress. Okay, so in other words, Congress could literally begin to decide and vote on and have a national conversation with regards to abortion. Okay, in other words, they can set the appellate jurisdiction. They can tell the court, listen, you don't have to hear cases. In fact, you're prohibited from hearing cases regarding abortion or some other controversial subject. Take euthanasia. Okay, take transgender issues or things like that. Some of these hot button issues can be basically prevented from going to the Supreme Court and or appeals courts in the federal system, and can be dealt with at the congressional level. Why doesn't Congress do that? Well, again, many of these issues are hot potato issues that could get you removed from office because of an unfavorable vote. And so Congress is very happy to punt these to the Supreme Court. But again, it's a reform that could take place. If you go to the next slide there, again, you're welcome to take a look at that video if it's still posted on YouTube on slide number 52. In the Neil Gorsuch hearings before the Senate, he addresses questions regarding why courts should be independent and disconnected from the people, disconnected from democratic give and take, okay? If you look at slides number 53 and 54, this is some pushback by the anti-federalists when they looked at the Constitution and they saw the Supreme Court. One of the first things they were concerned about is they thought that the Supreme Court would have the ability to call, basically strike down congressional laws, to call them null and void. And they thought that that was an extraordinary power grab, that courts should not be able to do that. Okay, they should be able to adjudicate according to the law, but not strike down federal laws or laws of Congress. Okay, which Technically, the Supreme Court didn't have that power. It was created by the Supreme Court in Marbury versus Madison in 1803, if you remember that case. But basically, the Anti-Federalists saw what was coming, and their vision was very, very prescient. Okay, I think they really picked this up. So let me just read this section here. This is called Brutus 15. Again, this is an Anti-Federalist paper after they looked at what was in the Constitution with regard to the Supreme Court. This is what they said. They said that their concern was the Supreme Court under this Constitution would be exalted above all other power in the government and subject to no control. The judges in England hold their office during their good behavior, but then their determinations are subject to correction by the House of Lords. So in other words, in the mechanism in the British system is that if their Congress, or the House of Lords is like our Senate, if they do not like a decision by their court, their Supreme Court, it can be modified by their Senate, their version of the Senate, the House of Lords. And their concern is their power is no means so extensive as that of the proposed Supreme Court of the Union. I believe that they in no instance assume the authority to set aside an act of Parliament under the idea that it is inconsistent with their Constitution. They consider themselves bound, again, they talk about the Brits, they consider themselves bound to decide according to the existing laws of the land and never undertake to control them by adjudging that they are inconsistent with the Constitution, much less are they vested with the power of giving equitable construction to the Constitution. In other words, the Anti-Federalists are like, listen, what we're seeing here is when the Supreme Court makes a ruling, it's going to be law, constitutional law, in the same way that Congress got a law passed and signed by a president. Okay, in other words, that's an extraordinary grant of power to the Supreme Court. Perhaps you need to rethink this. Okay, moving on to slide number 54. They say the judges in England are under the control of the legislature, for they are bound to determine according to the laws passed under them. But the judges under this Constitution will control the legislature, for the Supreme Court are authorized in the last resort to determine what is the extent of the powers of Congress. Okay, so in other words, whereas in the British system, the Congress can control the power of the court, in our system, they were very concerned that the court is going to control Congress. They are to give the Constitution an explanation, and there is no power above them to set aside their judgment. Okay, is that true? To a great degree, yes. Congress can rewrite or revise a law, but it's, in other words, the Supreme Court is the court of last resort. The only way that a Supreme Court decision can be overruled, or one way, and it has happened in our history, and we've talked about this before, is through a civil war. Dred Scott versus Sanford was basically overturned by a civil war. Continuing here, he said, the framers of this Constitution appear to have followed that of the British in rendering judges independent by granting them their office during good behavior without following the Constitution of England, in instituting a tribunal in which their errors may be corrected, and without adverting to this, that the judicial under this system have a power which is above the legislative, and which indeed transcends any power before given to a judicial by any free government under heaven. So again, the Anti-Federalists were very concerned. Was their warning heeded by the Federalists? No. Looking back now some 200 years, was their warning accurate? I think so. I really do. Okay, I'm going to stop there, and I'll continue with slide 55 next time.